lawyer Atsu Dogbe. Ewa ahomaso constitutional lawyer. Lawyer na pe machi. Lawyer.
Good morning.
Boko there.
Good morning. Boko.
Enra beto dwa say Chief Justice suspension bi aba na Ghana for bi na ebisa say we no political and say constitutionally no say yehu prima facie case efa Chief Justice bi ho a then the arrangement or what is in the constitution then they can efa the removal of a Chief Justice.
Well, thank you very much. I don't know if I'm permitted to speak in the English.
Oh, bet me a cabrofo. Say, Trini, out there, out to me cabrofo.
Well, thank you very much. And good morning to your listeners.
Good morning to you too.
So, as expected, on the mandate of the President and the National Intent, the Article 140.
Yeah.
But when the President received a petition, he is also supposed to forward it to the Council of State for both of them to determine whether there's a prima facie. And although that in the face of the court, Supreme Court has popularly known as Gertrude. And the news.
Line Nemonte Papa, we can hear you well.
Okay, so I mentioned earlier
yeah,
that when the President received a petition, I don't know if it is clearer now.
Yes, better.
Is it better?
Yes, please.
Thank you. So I was saying earlier that the moment the President receives of a petition, he is constitutionally mandated to forward same to the Council of State. Now that requirement, at least on the face of the Constitution, would have meant that the moment he does that forwarding, there should be a setting up of a committee. But in the same Supreme Court ruling in Gertrude versus the Attorney General, the court said there should be a determination of a prima facie case. The prima facie case simply means that the parties, in this case, the President, in consultation with the Council of State, jointly must come to an assessment whether the petitions that have been advanced have some merit or it is not frivolous, or that the party, in this case the Chief Justice, has questions to answer. It is after that assessment that the committee is set up. So at this point, the prima facie case simply means that the minds of the Council of State and the President is agreeable to the fact that there are questions to answer. It doesn't point to any guilt. It doesn't prejudice the process. It is a constitutional arrangement that they must determine a prima facie case. That is to say that on the face of the petition, are there questions to answer? And that determination has been made.
Now, just a moment. Ebiaka say that particular constitutional seminar or Article 146 no Tokuro kakra dem. Ebi kire say ebema president to mean to say institution no betimi weekend no. I mean, ebiaka aka say nke be ya sa emra na constitution review no omo ye ne nka omo nyimfiri ho say be ya ebema institutions no. As a constitutional lawyer, do you agree with some of those who are saying that particular Emrano and Shadamwa, it would give any president at all, so no issue, find a prima facie case against the way you feel?
So, in my own perspective, how the Constitution was arranged, or how it is arranged in fact, is what the Supreme Court feared would have triggered the frivolous removal of Chief Justices. That is why in AJ2 versus the Attorney General, the Supreme Court mandated that there should be a determination of a prima facie case. Now, that decision of the judge by the Supreme Court in the AJ2 versus Attorney General case was fostered by the view to remove the frivolous, or if you like, the political indiscretion, to remove Chief Justices. That is why they said you must determine a prima facie case.
But here is the case
not done by the president alone.
Here is the case that this Council of State, a few of them, any at all, Muswaba, appointed by the president. The president is the one, and then with Council of State, and they be determined prima facie na ye ka ho asem. Petition ni bi by another time. Onua in the Council of State but and they petition Korea Saba. John Mahama and the Council of State and who say insuo wumti or more entrance and set committee no mushim. I mean, if really there was something wrong with Chief Justice, the first petition that came out, John Draman Nanado should, and I am hearing that petition that Nanado acted on, not Ebiaba more, and that wasn't the only one Anaba. And Osha, what is happening now could have happened at that time, but they didn't find any prima facie case. That is where some believe that politically you could be targeted, and once it is the president and Council of State, Bisusu say president will, and then start the Council of State, so it can, politically motivate that to get you out.
Very well. So let me address it on two grounds. First,
right.
The composition of the Council of State, and then the earlier petition. On the composition of the Council of State, although some members are appointed by the president, these are members of some repute. For example, take the current composition of the Council of State.
Right.
We have even the former Chief Justice. The former Chief Justice.
Sophia Akufu.
As a member of the former Chief Justice Sophia Akufu, as a member of the Council of State. We have persons of repute, persons that cannot easily, if we are saying that the president has some political will to maneuver, these are not people that I think, looking at their record, would easily be maneuvered. And indeed, the earlier petition, something happened interestingly about the earlier petition. It was leaked to the public. We knew of the contents. How it came into the public domain, we did not know. This very one, the law mandates that all the proceedings are held in camera, including the content of the petition.
Right.
For some reason, this very institution or this very government has decided to comply with what the court itself has said in decisions such as Justice Berry versus Tiger IPI, that all the proceedings should be held in camera. That is, they should be private in order to preserve the integrity of the one going through the process. So for the first time, we are seeing a government that is trying to be careful and follow the dictates of the Supreme Court in respect of what the law should be. So we don't even have the benefit of the petition. So the earlier one, we were able to make assessments because we have seen the petition from Professor Kweku Asari.
Yes.
We have seen how things have gone. But this one, everything is happening in camera. So we are very careful to perhaps say that the petitions are similar to the earlier one, or because we have no benefit of what the content of the petition is. As mandated by law, it also has been in camera. And for the first time, we are seeing that adherence to the court's view of what in camera means in respect of the 146 proceedings. Every little part of the proceedings must not be made public. These are persons of high repute that any such publication of such findings or such processes may impugn their integrity. That is why so far we have not seen anything in the petition to make an assessment comparatively as to whether or not the earlier decision that there was no prima facie case will still hold today, because we have no benefit of the petition.
Martin, now I say an person ya bray besan baba can we will have a conversation because in some nothing now starting to thank you so much. Lawyer Kenneth Atsu Dogbe and out in can was him Rakwan so na ban we afa what Chief Justice when you went one form can be aso.